evidence presented to warrant a bond revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge. There was no like threat of like harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting anyone in danger, threatening danger, anything of that sort.
This is where
I have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Yes, sir.
Take a seat.
Thank you, Judge. Back to the point. Do you have a preference on the reset date, Judge?
Tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I'll add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please?
One courtroom, multiple defendants, zero patience for excuses. From threats and failed tests to drunk driving and violence, the judge draws a hard line. Every word, every warning, every choice now carries consequences.
October 20th.
I also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry. You're right. You said
Then
2
I'll
weeks.
test them back and we'll see.
Do you
But
want?
by then it'll be sufficient benefit that
Yes,
there's
Judge.
just no argument.
Do you want him 2 weeks from today testing on that date?
Yeah.
Okay. We'll do. Thank you, Judge.
For sure, Nate. You are Jonathan Leatherwood.
Yes, sir.
Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers were dispatched to a crash in Harris County, Texas. Officers arrived and observed the defendant as the sole occupant in the driver's seat. They observed red glossy eyes, strong odor of alcohol, slurred speech, and unsteadiness. Complaining witness told officers she was sitting at a red light when the defendant rear-ended her. Complaining to defendant's car and observed an open can of beer in the cup holder. SFSTs conducted 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to blood sample. His license is eligible and this is his first DWI, Judge.
Open container of beer while drinking, you say?
Yes, sir.
Mr. Leatherwood, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay, I'm now taking away your privilege to drive. You are not allowed to drive. Do you understand? I'm also making that a condition of your bond. I would hope that you understand it's elementary that you're not to have alcohol in the car while you are driving. Do you understand?
Yes, sir.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Strauss. If he tells me he can't get a hold of you, you pick up a new case, you endanger my county, I'm going to revoke your bond. No more PR bonds for you. Do you understand? All right. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria where we'll have you sign a reset. After that, we'll get you with Felicia for your bond conditions. And after that, you're free to go.
Yeah, Judge, we believe, Your Honor, what was in the car was an energy drink, Judge. It was not alcohol, Your Honor.
It's just what's alleged, Judge. I mean, I don't have a photo of the
Judge, he has
can.
no priors. We would ask you, Judge, to allow him to drive while on bond.
They're alleging he's got an open container of beer in the car while he's driving. I mean, you know, if you show me that it's not, I'll take it away. But I mean, they're telling me it's an open container of beer. So do this. Is the video here? Do you have anything?
Yeah, it looks like we have some body cam, Judge.
Okay, do you want to take a look real quick to see if you see something different?
Take a look. Your
No,
Honor.
I mean, we've got time. It's
Yes, sir.
9:45, you know,
Yes.
we've got
Take a
all
look on
day.
your approach.
Well, not all day, but you know,
Sir.
take a look real quick. I'll put this on hold if you find something different, you know,
Yes,
and
sir.
once they have time, they can go out, reach to the officer, see, hey, was it really an energy drink? Was it a beer? And let's see. But if he's drinking and he's in the car and they're alleging that, no, you know, there has to,
We'll go look at it.
yeah, sure, for sure. Mr. Leatherwood, heed this warning. You won't get another one. Do you understand? Okay, come on.
All right, Davis, come on up, page 7.
What, hey, Vic, what page? 17?
7, last name Davis.
Good morning, Mr. Davis. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complaining witness and the defendant are married. Officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness who stated that she had called the defendant and noticed that he was intoxicated. The complaining witness then drove to the defendant's location to take his keys to make sure that he would not drive. The defendant
Smart. Wonderful.
The defendant refused to give her the keys. The keys ended up on the ground. The complaining witness went to pick the keys up and the defendant started grabbing her, pushing her, and hugging her as they both fell onto the ground. Complaining witness said that she fell onto the ground and she felt pain and discomfort, and the defendant was on top of her. The officer noticed the defendant was much larger than the complaining witness, leading him to believe that the defendant falling on top of her would cause pain as well.
So did he intentionally assault? Was it an accident? I don't, read it again. You said he fell on top of her. Isn't that what you said?
Yes, Judge. He hugged her and then they both fell to the ground. And then he had fallen on top of her when they fell to the ground.
This is a specific intent crime.
I don't think we have an offense report, Judge.
Well, nevertheless, this is what we do now. This is the probable cause hearing. You got to have it now.
This is a DVD case, Judge. I don't think that the complaining witness has been ripped yet.
Doesn't matter. We got what we got here, and I don't see intent. You know, in life, Mr. Davis, it's Davis, right? There are people who drink, they become very happy. You know, they're great to hang out with. They crack jokes. They're just the life of the party. And then there are those people, when they drink, they become the devil incarnate. They get horns. They just become terrible. If this strikes a familiar chord, don't drink. You know, it sounds like someone's trying to do something very loving, you know, really. I'm going to find no probable cause now because I don't see intent, but just be careful. You know what I mean? Just, you got one life. Be happy and be nice. All right? Just take a seat for me, please.
All right, Judge, next is case 17, Laverne, Asia.
I'm sorry, I missed the page. I was like
17.
zoning. Ms. Laverne? Good morning. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Complaining witness and the defendant were dating for 6 months. On 12/4, officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness, who stated that the complaining witness and the defendant were at their uncle's house for food. When the defendant became angry, the complainant had received a call from another girl. Complainant called the girl back to prove she wasn't cheating, or he wasn't cheating. Defendant snatched the phone from complaining witness and began screaming at other party. Defendant grabbed complainant by the throat with her hand and struck him multiple times with a closed fist, causing pain. Complainant called police when the arguing calmed down. The witness stated he did not observe the fighting, but did hear defendant say, I hit you, and I'll do it again. No visible injuries were observed on either party.
Ma'am, I'm going to find that there's probable cause to go forward with your case. Do we know, do you guys have the rip done? Do we know if he wants to continue to have contact with her?
The DVD case, Judge, and we don't have the rip on this.
Okay. I don't know if he wants to have contact with you. So until I know what his wishes are, I'm going to order you not to have contact with this person. Do you understand? Ms. Laverne, I want you to understand that I'm going to protect every person in my county. If I have to put you in custody, I'll do it in a heartbeat to protect everyone. Do you understand? There's a protective order that's been issued in this case. You need to get to know it. If you violate this protective order, the state can file a violation of protective order. It's one of the worst cases you can pick up. There's a residential restriction. There's things that you can't do. So take note and don't have any contact. Don't have any weapons with this person. Do you have any questions? Well, I don't want to talk about the case. I'm just over the conditions. Do you have any questions? How old are you, man?
22.
You're 20. What do you do for a living?
I'm going to school.
Where do you go to school?
San Jacinto.
Okay. Do you work?
Yes.
What do you do?
I'm a dancer.
A dancer.
Yes.
Did you want to apply for an appointed lawyer, ma'am? Okay. I'm going to order you also as a condition of your bond not to use alcohol or any kind of illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke your bond. I'm not asking much from you. All I'm asking you to do is follow the law. Don't use alcohol. Don't use drugs. I'm going to test you. Do you understand? In fact, I think I'm going to send you for a test today because I want to know what, if anything, is in your system. Come back, and then I'm going to find you a lawyer, ma'am. All right? Okay, please. Hi, Casey.
Hey, how you doing?
Two.
I do have a plea for you today on Mr. Bryant.
You said Mr. Bryant?
Yes, Jason Bryant.
Okay, good morning, Mr. Bryant. Oh,
So it is actually not a second.
Your Honor, if I may, it's not a second because our investigator reached out to the county and found that the records were expunged. So,
but still,
Your Honor, under the code, you can't use expunged records for purpose of enhancement. And we reached out to appellate to confirm that as well as other people, as well as from the AG's office, and they've all.
so what happened? Did it get dismissed?
So
Expunged?
It's conviction.
it's a conviction that was
You still
expunged.
enhance it to a second?
We can't use
Not
the
with an
expunged records,
expunction.
Your Honor.
Technically, they shouldn't even know about it.
Yes, that's the issue. So for that reason is why we put a reduction to a first.
So
Yes.
we could refile it as a first, but we're not allowed, like per our appellate division, we can't use it for enhancement purposes, like to upcharge to a second.
Here's the thing. You've already had one that's dismissed. You now pick up another one, right? You know, when do we say when? When do the proverbial slaps on the wrist stop? You know, how old are you now?
41.
You're 41. When do we get it? You know, do you watch the news? How many times a day do people die in Harris County because of a DWI?
Every day, all the time.
Every freaking day, every single day. And the problem here is that what I have found when we go too low on punishment with repeat offenders, I have found that they wrap their car around a pole the next week. And that's why I have an extremely hard time of taking another proverbial slap on the wrist if you've even had one dismissed. Because who's to say you've learned anything? Tell me about the facts, will you, please?
Yes, Judge. One moment, Judge. So the facts were the officers were dispatched to a major crash call, and a witness stated he arrived at the accident, observed the defendant sitting in the driver's seat of the vehicle with the engine still on, and saw the defendant get out of the vehicle and sit by a tree. The officers observed the defendant to be sitting under the tree near the vehicle and was.
Did you say there was an accident?
It was a single car
It was a single
accident,
accident. He
Judge.
had hit a tree, and then he was being treated by HFD upon the arrival of the officers. And the defendant's vehicle had right bumper damage and windshield down and the glove box open from the accident. And that's when the officers found a
2 guns.
a loaded handgun on the sidewalk and another single 9mm near the vehicle. And then the officers then observed bloodshot, watery eyes, slurred speech, and a strong odor of alcohol coming from the defendant. And the defendant was unable to walk due to the injuries from the accident. The defendant admitted to driving, crashing the vehicle, and owning the firearm. He also admitted to consuming the alcohol. And that's when the defendant was transported to Memorial Hermann by ambulance and was unable to perform SFSTs due to the hospital visit. And a blood draw was performed.
What was the blood?
It came back at 0.153.
Did you guys enhance it to a 15 above?
No, Your Honor, we did not.
How did they even charge it as a second when you're telling them expunged?
Originally, it was charged using the expunged records because they only ran an NCIC, and for some reason it came up on NCIC when it shouldn't have. That's the issue.
Forever, for the rest of your life, you now see, even if it's expunged, people still see it. Doesn't matter. You know, in the future, going forward, what do you think is going to happen if you get pulled over and an officer looks at your record? Right. From now on, you're looking at a minimum of 30 days in jail. I'm going to tell you now, Mr. Bryant, I don't want to take this. I don't think it's fair. You know, I don't on any seconds because, you know, there has to be consequence for behavior and it's not fair. This is the last time you will get a proverbial slap on the wrist. I want you to understand that. Anytime you get pulled over, they're going to see all this. You will get taken down. All you have to do is push a button on your freaking phone. $30 to $40 on an Uber will take you anywhere you need to go. Do you understand how much money have you paid them to represent you? How much money have you paid to represent on the first freaking DWI? And now you're back. I'm going to tell you, if you act like a child, I'm going to treat you like a child, and I'm going to put you over my knee, and I'm going to spank you like a little child. You come back here, but I'm going to do it with a ton of jail time. Do you understand?
Sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Do you understand? how to plead to the offense of driving while intoxicated. I will find you guilty. I will send you to 3 days in jail. I'll give you credit for 1. I'm going to suspend your license for a year. Do not drive until you get a license. I am also now going to hit you with these DPS surcharge that you will be required to pay. That is a $3,000 surcharge you're going to be required to pay. You will also be required to pay the court costs, which are around $400 to $500. And I'm going to tell you, we're going to get it one way or the other, because if you don't, every $100 that you owe, you will be sitting 1 day in jail. So you can imagine on a $35,000 to $4,000 bill right now that you're going to get, how much you will sit in jail.
Sure.
I want you to understand that we will not tolerate DWIs in Harris County, and we're going to get blood one way or the other. You understand?
Yes, sir.
It's just not fair when it's so easy to find another way. You know, I like to drink. I like to drink a lot. I love my mules, really, really spicy. And I love to go out with my wife. How do you think I do it though? Right. And then I can just be towed, you know, but that's the responsible thing to do. And I hope that you really get it from now on, because God forbid you do something that you really can't walk away from. Do you understand?
Sir.
All right. Good luck. Thank you. Hi, Ms. Brown. How are you? I'm sorry to see you in this circumstance. You know, you now picked up a terroristic threat, serious bodily injury. You're facing a year in jail. You know, the thing that I told all of them that I'm happy that you didn't follow through. That, you know, sticks and stones, right? But words can hurt sometimes, right? As you now see, you've now picked up a new case. I don't know how we go forward now. What do we do? I don't know either. You're 19, right? Where do we go? Because you had a home to go to, but we don't know if we can put you back in the home. No way under any circumstance am I going to let you just out on the street. That's a death sentence. Because where would you go? Who are you going to be with? How are you going to eat? I can't do that. We can't just give you a PR bond. I have to know where you're going to go, who you're going to be with, so we don't set you up for failure. Do you know the phone number to that house? Have you given it to Josh? Okay. Don't say it out loud. If you can write it down, we're going to try to get in contact with them. We can call now so that we can see if they're willing to take you back, and then we'll go from there. Because I don't know how we're going to go forward. I don't want to let you out on the street. Is there anyone here, do you know, for her? You've been in contact with the caseworker or social worker or no?
The caseworker, and then also her appointed guardian.
Have you talked to them lately?
Not since this new case.
Okay, so I guess, can we try to do that today? Let's roll it to tomorrow. Let's see, are they going to accept her back? If not, how do we go forward? I don't want to keep you here for a long time, but I don't know how to go forward at this time. So let's give it a day. Let's see what Josh can find, and then we'll bring you back, okay? All right, sticks and stones. I'm glad that you didn't follow through. That's good. Now we have to get you to learn self-control so that you don't flip out. That's the name of the game now. All right? Think about it. Okay. All right. Thanks. Antonio.
Good morning, Your Honor. This is a new appointment, Sandra Dawn Stumbo. It's a 2019 case. State, apparently there's no evidence, and I guess they want to evaluate it for dismissal.
Yes, Judge. Right now, we just put in the request because at the time, I guess they didn't request the body cam and dash. So yes, Judge.
Oof.
We're going to reach out to see if we can get that within the next week or so, 2 weeks.
No. I'm not going long. I mean, this case is, if you guys didn't do it back then, hey,
Yes,
this case is over 2,000 days old.
That we're gonna look, see what we do have, and we'll likely be willing to dismiss after we look at it briefly.
Okay, let's set it a week.
Yes, sir.
I'm not gonna waive her appearance.
All right.
Come up, Ms. Stumbo. If you ever take off on me again, there are going to be so many zeros behind that bond. You're going to be looking at 59s. Do you understand? You must be back in a week so we can determine where we're going to go with this case.
Can I explain why?
Doesn't matter. You have to understand, your excuse goes in one ear, goes out the other. The only thing that matters are choices. You can either make a good choice in life or you can make the wrong choice. When you show up to court, good things happen. And when you don't, there's consequence. You're old enough to understand that. Like I said, you take off on me again, get ready, because it's going to be a long ride. Okay, Antonio, we'll see you in a week.
Thank you, Judge.
Thanks, bud.
Hey, Judge, I had a quick question for you also on Booker. So you said that we could reset her. She went and did a drug test today and was clear.
Great.
So I was gonna see if we could reset her out till after the new year. She's been coming back for GED proof.
That's right. Yeah, I'm okay with
She
that.
showed me, she's called, almost a dozen different places. She's working to get into it. I think that I think it's the timing of the year. It's somewhere.
Come on, Ms. Booker.
Yeah.
But that's like a month, and I want to make sure that is she in and doing the studies or she hasn't gotten in yet?
She showed me a lot of screenshots. People are responding and we're gonna get back to you. And she's spoken with people in person.
Yeah, I spoke
So what's happening?
I spoke to Mr. Charles Jackson on the career and recovery. He
Oh,
says,
yes. Isn't that the guy that we spoke to?
Last time she was here, we spoke to him on the phone.
Was it regarding her case or was that someone else?
I want to say hers.
So we didn't have the specific
Yeah.
last time we were here. We got the list at the end of the last set.
yeah.
Who was that with?
But he said he wasn't taking any clients until January 8th. And
Oh, this is a great guy. We have him. We had him on another person. And remember, I called and it wasn't her, Stephen. It was someone else. And God, who was it?
It was Connor's client.
Here, see,
Yes, right. Good job. Dan, you're the best. You're so good.
yeah,
He's a good guy. I like him.
I did speak to him.
Okay, so then if he's, okay, I'm willing to wait for you to get with Mr. Jackson.
List.
But
Okay, yeah.
get on the list. Don't mess around.
I'm not, of course.
Okay, so what did he say? What day?
He said January 8th is when he's taking new clients.
Okay. So let's set you for January 9th. I want to make sure that you get in with this guy, okay? If for some reason that day you don't get in, I'm going to call him myself.
Okay.
So that one way we'll get, okay? But just call him back, say, hey, man, I talked to my judge. Judge is cool with it. We're going to wait for me to get in with you guys because he knows you and he likes you.
Okay.
So that way it's more kind of, you build a rapport with this person, okay?
Thank you.
Do that and we'll wait for you to get it in and we'll get you out with that GED one way or the other. Okay? All right. Thanks, Josh. All right. Good job.
In this courtroom, attitude doesn't win. Accountability does. Warnings are given once. After that, consequences hit fast and hard. The lesson is simple. Follow the conditions or face the time.